behalf of the petitioner of counsel herein. The petitioner herein had informed me that he believes that he was denied his rights to a line of duty pension as a result of illegal and fraudulent activity perpetrated upon him by the New York City Fire Department and the 1B Pension Board. In particular, it is petitioner's contention that two individuals, Mary O'Sullivan and Marlene Gold, were at the time in charge of supervising documents, medical reports, and determinations of pension awards, were guilty of certifying medical reports and withholding medical reports and documents of which petitioner has signed receipts for and which would have resulted in the petitioner being awarded a line of duty pension as opposed to an ordinary pension. It is also petitioner's contention that Mary O'Sullivan had been writing, and after that in quotes, drafting, petitioner's very own 1B medical board certificates. This is due to the fact that the first, second, and third 1B boards had no medical evidence of any kind to come to the decisions as written on such 1B certificates. Also, petitioner has evidence that shows Miss O'Sullivan was writing and drafting medical certificates in letters written by Fire Department Deputy Fire Commissioner Clinton of the Fire Department Board of Trustees. The Supreme Court's written decision in petitioner's Article 78, meaning mine, and September 22nd, 1993, by the Honorable Judge Vaccaro, where I won my case, which in part states, in addition, the court finds that there is an absence in the medical records of any support for the medical board's position as set forth in the first three reports that petitioner's disability was caused by 1983 or 1987 non-service related incidences, since in no report of these incidences is there any mention of neck or back pain. In part, nor is there any sufficient credible medical evidence to support the position of the medical board as posed in their fourth and fifth reports that a nucleus condition termed, quote, pain syndrome is the cause of petitioner's disability. In part, the court finds their determination to be arbitrary and capricious, in quotes, in favor of petition, that as a result of the respondent's activities, relevant records were deleted and omitted from the files submitted to the courts in connection with petitioner's underlying Article 78 proceeding. Upon being informed of these facts, petitioner's attorney Gary Barinholtz, Esquire, and I, meaning Judge Aiello, contacted the Kings County District Attorney's Office and met with Charles Guerra, Assistant District Attorney in charge of the Rackets Bureau. At a meeting with the petitioner and Mr. Guerra, these facts, together with numerous documents, were presented to Mr. Guerra for review. Mr. Guerra opened an investigation and proceeded to gather information and research various legal aspects of petitioner's claim, which took place over a period of 16 months. Upon recent completion of Mr. Guerra's inquiry and investigation, and after a number of meetings, he met with petitioner, Mr. Barinholtz, and me, meaning Judge Aiello. Mr. Guerra stated that he believed that there was wrongdoing in the connection with the handling of petitioner's pension application, thereby depriving petitioner of his line of duty disability, and that voluminous documents were in fact missing from petitioner's file, including medical reports from the Fire Department's 3-man medical board, the 1B medical board, and the Fire Department Board of Trustees, as well as from documents submitted by the Corporation Counsel to the Supreme Court and to the Appellate Division in connection with prior court proceedings commenced by petitioner. Mr. Guerra also stated that he believed that former members Mary O'Sullivan, and Marlene Gold of the Fire Department, 1B Board, and Board of Trustees were responsible in the way in which his disability case was handled, and these two individuals were directly related and responsible for petitioner's denial of his accidental disability. Due to the fact that petitioner's dispute over these documents dates back approximately 10 years, it is impossible at this juncture for the District Attorney's Office to proceed with a criminal prosecution at this time. However, this does not bar Mr. Romanelli's attempt to pursue his legal remedies civilly based upon the apparent fraud perpetrated herein. Petitioner's application to renew his Article 78 proceedings should be granted in all aspects. This letter is dated, 4-page letter, is dated November 28th, 2000, signed by Ronald Aiello, the former Supreme Court judge, criminal judge. The only thing missing from this signed affirmation by Judge Aiello is when Guerra stated that my case was the worst case of pension fraud he ever investigated. Now, with this 4-page signed affirmation, I go back again to the New York State Brooklyn Supreme Court in January 2001. This time I take this signed affirmation again, which is my new case. This is a fraud case under 13377, which is under the Fire Department Administrative Laws in the New York City Charter, called fraud or mistake. There is no statute of limitations on this law. Along with the signed, like I said, affirmation by Ronald Aiello, the case goes before now, it goes before a Judge Nicholas Clementi in Brooklyn. This is the first time a firefighter has ever taken a fraud case in New York City to court. What happens next in this case is mind-boggling again. Guess who's handling the opposition to my fraud case from the New York City Corporation Council? Again, Madga Deconinck. Can we believe this? This is 12 years later, and Madga Deconinck is fighting my fraud case now. She was the Fire Department Board of Trustee member. If you remember, stated at the very beginning of my case that she said that someone was altering my medical certificate, and as she stated, I never had a previous neck or back injury on record, and the only injury I had was my line of duty injury from when I was injured in the fire. Also, the chief medical officer concurred with that on record. And Madga Deconinck also stated it was the only injury I received on line, it was my line of duty injury. Well, 12 years later, you'd think the fraud would stop. It doesn't. It still continues.